started your application for Section 174. The evidence is standardized and static as it is. The court can't introduce new evidence because the defense has closed its case.
Yes.
And you are assailing the defendant's case.
Yes.
That's why I'm not allowed to. There are two divergent decisions in our courts. State versus Bosolu. It's an SCA case. And then there's another case also. State versus Roll. R versus Roll. Okay. So, are you sure that it's not me who introduced that? I couldn't introduce anything.
Yes. No.
Unless I mentioned that I'm doing so in terms of Section 186.
Yes, it is already on record, and I've just had a look at Exhibit J. It's indeed under oath.
Who introduced it anyway?
My lord, when we go back
Yeah.
on the record, we see that during the cross-examination of Ms. Zandi Khumalo,
Right.
on the 20th of July 2023,
Yeah.
during the cross-examination of Mr. Ramusepeli,
Mr. Ramsepi introduced it.
yes, when cross-examining Ms. Zandi Khumalo,
Yeah.
he referred to it, and it's page 7 on the 20th of July 2023, lines 1 to 4, and also on the 8th of November 2024, during the cross-examination of Brigadier Gininda, Mr. Ramsepele referred to it, and we here, my lord, we specifically referred to Makaleni, the cross-examination of Makaleni.
Right.
8th of November 2024, page 53, lines 6 to 22. That's where Mr. Ramsepele canvassed the oral statement made to Warrant Officer Steenkamp with Brigadier Gininda.
Okay.
Yes.
You had confirmed that, Mr. Ramsepi.
This is the court, my lord. My lord, although I do not have the record that my colleague talks about, indeed, I did cross-examine Ms. Zandile Khumalo, specifically regarding the people that were in the house.
No, fine, no problem.
Regarding their description of the second intruder.
No, fine, there's no problem.
I did not touch anything on Makaleni with those witnesses. And my lord, we must be very...
No, it's okay. All I'm saying, I
Yes.
wanted to
Yes.
ascertain is, it doesn't matter who handled that cross-examination.
Yes.
All I want to ascertain is, it was handled before Mr. Ngomalo began his 174 application. That's all the law says.
Yes.
Okay, fine, no problem.
Okay. And further, my lord, this aspect, because I was going to request the court perhaps after the interpretation and the reply by Advocate Ngomalo, perhaps to have also a reply, a word or two, although I did not make an application myself. I'm not sure whether it's procedural, so I was going to...
What does the law say?
Request the court's indulgence, my lord, because I don't know whether it's procedural. I'll concede that, my lord.
Talk to your learned colleagues there.
No, they can't teach me anything, my lord.
That's all?
They can't teach me anything.
Is it?
Yes.
Okay, let's start. You'll decide about that.
Okay.
Yes, you can continue, sir.
States resubmissions under paragraph 31.14.
Yeah.
At paragraph 23, joint possession of firearms. The test for joint possession of an illegal firearm and ammunition is well established The mere fact that the accused participated in a robbery where his co-perpetrators possessed firearms does not sustain beyond a reasonable doubt in the inference that the accused possessed the firearms jointly with them. In S versus Nkosi 1998, volume 1, SACR 284, open bracket W, close bracket. Lapho kwakhuluma khona-ke ngesivivinyo-ke uma sebuka-ke udaba lwey'bhamu-ke ey'hlangene lapho-ke futhi nezinhlamvu-ke lapho-ke la bathi khona-ke uma ngaba-ke amsolwa futhi nabanye asebenzisane nabo-ke noma abambisene nabo-ke batholakala bephethe-ke ibhamu kuvame ukuthi lokho kuhambe kanjani-ke futhi baze bacaphuna kwicala-ke labanye-ke futhi-ke noma icala-ke lombuso lubhekene necala lakaNkosi lango-1998 ngaphansi kovolume 1 SACR kumanye wamacala-ke walana eNingizimu Afrika. It was held that this is only justifiable if the factual evidence excludes all reasonable inferences other than A, that the group had the intention to exercise possession through the actual denter, and B, actual denter had the intention to hold the guns on behalf of the group. Only if both the requirements are fulfilled can there be a joint possession involving the group as a whole. Lapho kwakhuluma ukuthi lapho-ke uma ngaba mhlawumbe lokhu kuthetheleleka-ke ufakazi bakhona-ke lapho khona-ke mhlawumbe isizathu esibangela noma mhlawumbe ucabanga okungenangqondo lapho khona-ke inkulumo ukuthi lo daba lolu-ke uma ngaba mhlawumbe asithi mhlawumbe-ke abantu basebenzisa-ke ibhamu beyiqembu-ke lapho-ke ukuthi kuvame ukuthi lokhu kuhambe kanjani-ke futhi nokuthi yini abavame ukuthi bayibuke noma bayibukisise-ke lapho-ke kulolo daba lolo-ke. This court in S versus Ambuli 2003 volume 1 SACR 97 SCA pointed out that where the offense is a possession of a firearm in open bracket or in that case a hand generate close bracket, it is not the principles of a common purpose that have application, but rather those relating to joint possession. A conviction of joint possession can only be complete if more than one person possesses the firearm. The court found that mere knowledge by others that one member of a group possessed a hand generate or even acquisite it to its use of the execution of their own common purpose. Nalapho futhi kade bekhuluma khona-ke ngelinye-ke icala noma kade becaphule kwelinye-ke icala lombuso olubhekeneke necala lakambuli-ke lembuli-ke lapho-ke langomnyaka ka-2003 la bakhuluma khona-ke ngodaba lokuthi uma ngabe-ke abantu kade behamba beyiqembu bephethe-ke ibhamu lapho-ke kuvame ukuthi mhlawumbe lokusebenze kanjani-ke futhi nokuthi kusuke basebenza-ke ngaphansi kwenhloso-ke eyodwa lapho-ke ekuthizeni-ke benze lokhu abakwenzayo-ke noma inhloso evamile eyodwana mayelana nesicelo sabo mhlawumbe mayelana nodaba lwabo-ke abalwenzayo lapho-ke mayelana nodaba lolu-ke noma-ke ukuvuma ukuthi yebo kade bekhona omunye wabo kade aphethe ibhamu lapho-ke thizeni babulale-ke futhi benza lokho ngenhloso evamile. Paragraph 32.
Yeah, before you go there, that case of Mboli, was it correctly decided? I'm asking everybody.
Was it correctly cited?
Decided. I know he was involved. Well, he did say he was allegedly part of a group of males who entered and robbed a bank in Silverton, I think.
Yes.
He had a hand grenade apparently in his car. So he was charged, obviously.
Yes.
Even with, I think it was correctly decided because
Yes.
I think they argued that the other accused wouldn't have known that he has a hand grenade.
Yes.
I remember that case. It was done by Nugent, Nugent, and Mrs. Who's the old lady of politics, believed our Mr. Mbuli that he was never ever involved. Although Even the SCA agreed that apparently he was correctly convicted. But I'm just thinking, if for instance, like an AK-47, you storm a bank together, yeah, even there you could argue that I didn't know that Baloyi is going to come out with an AK-47.
Yes.
You could still get away with it. Fine. But it's a question where you have allegedly held a prior agreement meeting, and you get armed, all of you, and you all get into the bank armed, or some of you not armed. Maybe there it's a bit different.
Yes, indeed, but yeah, the latest authorities, the one that we cite, they're confirmed by the Constitutional Court that the tenter must have the intention to hold it on behalf of the group,
for the
and the
party.
group should have the intention to exercise possession through the detenter.
Right.
Yes.
Mr. What do you say?
My daughter, I've dealt with the aspects in my
Oh,
head
okay.
of my
You
case.
don't want to add anything? Fine. No problem.
I've covered it.
Okay.
Then under paragraph 32, it is submitted that the application for discharge ought to be dismissed. Then there's a signature underneath, and then underneath the signature, it reads as follows: Advocate R.N. Asibanda. Underneath, it's Advocate G.D. Baloyi, and then for the state, the date is it reads as follows: 22nd 08/2025. Lapho kwathi khona-ke lesicelo esike kwamethi kusenkantolo-ke esinqabe noma ingasivumi-ke leso sokuthi bakudedeleke mayelana nesigaba-ke lapho sezomthetho-ke sika-174. Bese-ke ngenzansi wakhona-ke umuntu osayindile lapho-ke bese babhala ukuthi advocate R.N. Asibanda, bese ngenzansi wakhona-ke babhala ukuthi advocate G.D. Baloyi, abaqhamuka noma abamele ithimba lezombuso-ke.
My Lord, there were additional submissions that we made regarding the evidence of Mr. Thabo Makaleni. We have given those additional submissions to Mr. Mzanga.
Yeah, fine.
And we indicated, my Lord, that there were some words in those submissions, typing errors, and we undertook to just neaten that up. We have since done that, my Lord. Yesterday, I gave my colleagues the version that has been cleaned up. It's just basically the same. The only difference, my Lord, is reference to the record, which I've just mentioned, my Lord.
Okay, fine.
So we'll just allow Mr. Mzanga just to interpret the initial submissions, and thereafter we'll then just in less than a minute, my Lord, just refer to the updated version.
My Lord, with the leave of the court, may I quickly confirm something with the state pertaining to these supplementary state submissions? So I've got 2 copies.
Yes.
Manje ngizofunda mayelana nodaba lwezethulo-ke lapho-ke ezengeziwe mayelana nodaba lwenkulumo ethimba-ke lwezombuso-ke. Resubmissions, supplementary submissions, it reads as follows: Mr. Thabang Makeleni, lapho-ke iyaqala ngaphansi kwale paragraph. My Lord, the paragraph, I think it's unnamed. It's page 31. Can therefore not be constructed as deliberately deviating from the approach followed in the Ndlovu case. And I quote: the writer refers to the Lubanzi 2010 volume 2 SACR 233 SCA case. Not allowing the hearsay admissions cannot necessarily be construed as criticism of the approach of the Ndlovu case. It was never the purpose of Section 3, subsection 1, paragraph C, to allow all hearsay evidence, but to grant a court the discretion to allow it. The court in this instance found cogent reason not to allow the evidence, of which the failure by the trial court to provide no reason at all must have played a major role. Lapho ke futhi bakhuluma khona ke ngodaba kwelinye ke icala lapho ke lapho bacaphune kwicala la kaNdlovu ke lapho futhi nelinye ke icala lika Libanzila ngo2010 noma elahlalwa phansi ngomnyaka ka2010 noma isinqumo sakhona esaqhamuka ngomnyaka ka2010 ke lapho ke bakhuluma ngodaba kwenkulumo ekungizwa kuphela ke ewela ngaphansi kwesigaba sezomthetho ka3 lapho ke futhi ngaphansi paragraph 1 no paragraph C wakhona ke ukuthi inkulumo ekungizwa kwamele ukuthi inkosi enkantolo noma ke inkantolo ibuke kanjani uma ngabe seyibuke seyibhekene nenkulumo ekufana ukuthi mhlawumbe inkulumo umuntu ayizwe komunye ke umuntu wesibili ke leyo ke kepha ingaqhamuki kulomuntu loqala noma lwesibili ayizwe kuyena ke. Paragraph 30, it is submitted that this is an appropriate case and in the interest of justice to evoke Section 3, subsection 1, paragraph C of the Hearsay Act, as there are many enough safeguards as there is sufficient corroboration for the extra crucial statements of accused number 2. As mentioned above, the firearm found in accused number 3's possession being ballistically linked to the bullet projectile found on the scene, and the fact that downloads showed that accused number 5 communicated with Kelly Kumar. Nalapho ke futhi bathi bacela ke futhi bethula lenkulumo yabo futhi ngokuyithoba futhi ngogcwele ngesicelo esikhulu ke lapho ke ukuthi kungaphansi kozobulungiswa bezomthetho ke ukuthi lapho ke isigaba saka section 3 noma u section 3 ke lapho ke isigaba sesithathu sezomthetho ke senkulumo kangizwa ukuthi kwamele ukuthi sisebenze ke lapho ke ngoba bathi khona ke ubufakazi obuhambisanayo kakhulu kakhulukazi ke malana no double statement zakamsola wesibili ke lezi ezengeziwe lezi athi khuluma khona ke umsola wesibili ke futhi nokuthi isibhamu sakamsola wesithathu ke noma mhlawumbe ilokozana projectile abayithola ke lapho ke yaqhumana nale kade khona ke ngaphakathi kwalamuzi eyosigameko ke umuzi lapho kwakhumalo futhi bathi ukuthi ngesikhathi kade bethubula inkulumo kade khona ngaphakathi emakhala ekhukhwini noma ke ucingweni ke labasolwa ke bathi khona kakamsola wesithathu wesihlanu ke lapho ke bathi kuyatshengakala khona ukuthi yena ke bekaqhumana noKhili Khumalo ucingweni. Mr. Thabo Makeleni made a statement on the 27th of October 2014, a day after the incident. The main thrust of this statement / evidence is captured in Exhibit J, page 5, first paragraph. The effect of the evidence is that he saw 3 unknown African males in the vicinity of the gas station, open bracket, visible on the Mhlahlo photos, busy on the cell phone. He saw them again at Kelly's mom's house. Suspect B stood at the gate. He gave the following description: African male, more or less 25 years, height 1.8 taller, slender build. Lapho khona kwathi inkulumo eyakhulunywa ke leyo uThabo Makeleni bathi statement sakhe ke wasikhuluma ngelanga la nge27 zaka October ngomnyaka ka2014 ngemuva kwelanga lesigameko ke bathi lapho ke ku statement sakhe mhlawumbe ufakazi bakhe bathi bucashuni wabubhaliwe ngaphansi kwemibukiso kaJ noma ke exhibit J ngesingisi ke ku cast lesihlanu lapho ke bathi ku paragraph lokuqala la yena akakhulumile khona ukuthi wabona ke abalisa abathathu ke balana iningizimu Afrika ke mhlawumbe abalisa abamnyama ke lapho ke bathi kule ndawo yalaphayana kula gas station ngesingisi mabeyibiza ke lapho ke bathi lokho kukhona ngaphakathi kwezithombe zakamhlahlo futhi nalapho athi wabona bematasatasa ocingweni noma okumakhala ekhukhwini babo ke lapho ke wabe futhi wabona ke lapho ke ngaphansi komuzi noma kulomuzi okwakhumalo lapho ke futhi athi umsolwa wesibili noma ususpect B ke noma umsolwa wesibili ke loyo ke kade ami lapho ke nakhe esangweni la ngaphandle egating ke ngesingisi bathi bese abanye lapho ke uqhubeka washo khona njalo ngesikhangiso sabo kade bejangakala ngaso ukuthi kade kuwabantu abajangakala kanjani ngokwesikhangiso sabo bathi wabona ke abantu abamnyama ke mhlawumbe insizwe ezimnyama ke lapho ke bathi omunye wakhona ke kade aneminyaka asithi cishe kwaba 50 ngaphansi noma ukuya ngaphezulu bathi ubude bakhe ke kade ku 1.8 ubude balomuntu ambonile laphayana bathi ngokomzimba kade kungasuye umuntu omkhulu noma umuntu omnciphile ngokomzimba kepha kade kumuntu nje ongathi slender ke ngohlobo akheke ngalo ke lo muntu medium brown complexion clothing hooded top witness saw a golden insert in upper teeth hairstyle dreadlock bathi lapho futhi washo khona njalo ukuthi umbala walomuntu ke noma indlela aqangala akusumuntu okhanyayo noma umuntu omnyama ngokwebala lakhe ke futhi bagqoke ke lapho kuyena ihoodie la kuyena ngaphezulu ijezi lakhona ke bathi futhi wabona waqapha ukuthi lo muntu kade anezinyo legolide la kuyena ke ngaphezulu esikhangiso noma indlela noma into kade nayo la ikhanda kuyena ke noma ikhanda lakhe ke inwele zakhe kade kuyinwele zama dreadlock Felicia his or facial hair, my apologies my lord, facial hair inwele zakhe bathi mustache and beard bathi inwele zakhe futhi ne mustache futhi ngisho nentshebe yakhona ke lapho ke witness saw something in his hand that could have been a firearm bathi ufakazi ikhona ke into wayibona ke kuyena ke lo muntu esandleni bekangathi mhlambi ke yisibhamu lesi awasibona under Roman figure 2 the defense themselves introduced this exhibit into the record. We submit therefore that they are concerted to the hearsay evidence of Mr. Makeleni being admitted on the record as advanced in section 3 subsection 1 paragraph A of the Law of Evidence Amendment Act 45 of 1988, which provides that subject to any other law, hearsay evidence shall not be admitted as evidence in a criminal proceedings. Lapho bathi khona ke ithimba labameli ke ibona ke baqhamukise lenkulumo lena ke ngaphakathi kwemibukiso lapho ke inkulumo kaMnumzana kaMakeleni futhi bona beqhamisela ngaphansi noma ngaphambi kwenkosi yenkantolo ke ngesikhathi kade behola ke noma kade bephenya ke noma kade bebuza ke imibuzo ke lana ke bathi futhi kwamele ukuthi bakufake ngaphansi kwesigaba noma inkosi yenkantolo ke kwamele ukuthi kwamkele ngaphansi kwesigaba sesithathu sezomthetho ke lapho seyinkulumo kungizwa nje kuphela ewela ngaphansi kwezomthetho ke lapho ke umthetho sisekelo ka 45 lana ke eNingizimu Afrika ke engomnyaka ka 1998. Unless each party against whom the evidence is to be adducted agrees to the admissions therefore bathi nalapho futhi ngaphandle nje kokuthi ke lapho ke asithi mhlawumbe maqembuka yazona ke ngale nkulumo uthi mhlawumbe kwamethi inkosi enkantolo ke leyo ke iyamukele njengendlela. Under Roman figure 3 alternatively the state will argue that it is in the interest of justice to admit it bathi lapho ke ngaphansi kwepha Roman figure 3 ngapha iphuzu lesithathu ke lapho ke ithimba lezombuso bazothi labo lokho ke bakuphike futhi bakhulume ngakho ke ukuthi lokukwela ke ngaphansi komthetho sisekelo mhlawumbe ngaphansi kwezamalungelo ezomthetho ukuthi lokhu kwamele ukuthi inkosi yenkantolo ke ikwamkele. In the case of Kapa versus the state, open bracket CCT 292/2021, 2023 ZACC 1 to 2023, Volume 4 BCLR 370, open bracket CC, close bracket 2003, Volume 1 SACR 583 CC 2024 January 2023 concerns the admissions of the hearsay evidence in terms of the interest of justice test as set out in section 3 subsection 1 paragraph C of the Law Evidence Amendment Act 45 of 1988. The Constitutional Court had occasion to consider whether the Western Cape High Court was correct under Section 3, Subsection 1, Paragraph C of the Law Evidence Amendment Act, Hearsay Act, to admit the statement of Ms. Bomikazi Dasi, who died before the trial. This case is on all fourth with the issue pertaining to the admissibility of Mr. Makeleni's statement. Lapho ke kade bebukisa futhi ngamanye ke amacala ke walapho ke ngaphambi kwenkosini kwephakeme lapho ke eKapa ke Kapa lodumo ke laba khona ke ngelinye icala bacapha icala la kaDasi ke icala kalombuso futhi necala la kabomkazi Dasi la bathi khona ke ubomkazi Dasi ke yena ke wabhala istatement sakhe kepha ke lesi statement lesikade asikhulumile noma istatement double statement sakhe kade ashilo lapho ke kepha washona ngaphambi kokuthi afike athule ufakazi bakhe ke phecelezi nestatement sakhe ke lapho ke Roman figure 4. The High Court had ruled that the statement of the witnesses who had since passed on was admissible under Section 3, subsection 1, paragraph C, Act 45 of 1988. Nalapho futhi kade besho khona ke ukuthi inkosi enkantolo ephakeme lapho ke elokuzana eKapa lodumo ke yasithatha ke statement esilesi bese futhi yasamukela ngaphansi kwenkulumo ewela ngaphansi kwesigaba sesithathu sezomthetho ke. Roman figure 5. The CC examined the provisions of Section 3, subsection 4 of the Hearsay Act defines hearsay as evidence, whether oral or in writing, the probative value of which depends upon a credibility of any person other than the person giving such evidence. Ms. Dasi's statement, as tendered by the state through the oral evidence of Sergeant Msolo, is hearsay evidence. The state successfully applied for the admission of this hearsay evidence in terms of Section 3, subsection 1, paragraph C of the Hearsay Act. Bathi lapho ke istatement sakhe ke futhi basamkela lapho ngokuthi kade khona ke inkulumo yakhe bayikhulumile kungizwa nje kuphela ke bathi lapho ke thimba ke lozombuso ke ibona ke abacela ukuthi inkosi enkantolo isamkele ke statement lesi sakhona ke saye lapho ke ulukuzana umufi lo muntu bekasele ashonile ke ngesikhathi icala lakhe kade likhulunywa futhi samkelo statement sakhe ngaphansi kwezomthetho noma ngaphansi kwesigaba sesithathu sezomthetho ke senkulumo kungizwa kuphela. Under Roman figure 6, section 3, subsection 1, paragraph C of the Hearsay Act provides as follows. 1. Subject to the provisions of any other law, hearsay evidence shall not be admitted as evidence at criminal or civil proceedings unless C. The court having regard to the nature of the proceedings. In the nature of the evidence, the purpose for which the evidence is tendered, the probative value of the evidence, the reason why the evidence is not given by the person upon whose credibility the probative value of such evidence depends, and then any prejudice to a party which the admissions of such evidence might entail, and any other factors which should, in opinion of the court, be taken in account. Is the opinion that such evidence should be admitted in the interest of justice. The interest of justice. Lapho ke bakhuluma futhi ngolunye ke udaba lwe-statement lezi ukuthi mhlambi kusenkantolo kwamele ibuke kanjani ke eziwela ngaphansi kwesigaba sezomthetho sesithathu lapho ke ekunkulumo kangizwa ke ukuthi lokho mhlambi kumacala ke asithi ke ezobugebengu zomthetho mhlambi kumacala ke lapho ke wama civil asimhlambi abahlukanisa khona ke imishado noma mhlambi khona ukuthiza bakwenzayo ke lapho ke ukuthi inkosenkantolo kumele lokho kubuke kanjani futhi nohlelo ekuhlalwe ngalo ukuthi kuhamba kanjani ke futhi nofakazi bakhona ke ukuthi ngabe mhlambi abulethe ngayiphi ke indlela nokuthi mhlambe ngabe ubani ke okhulumile ngodaba lolofakazi lobuke lapho ke nokuthi futhi lokhu ngeke mhlambe ucekele omunye ke umuntu noma ufakazi bakhe mhlambe ngeke ebuze uqukethe enye ke inkulumo engaphandle kodaba lolu bekakhuluma ngalo ke lapho ke nokuthi futhi kuwela ngaphansi kwezobulungiswa bezomthetho. It is well established a principle that a trial court's decision must be based on the totality of evidence available to the court. In respect of the applicant's convictions, the High Court reasoned based on the Section 220 admissions, the forensic evidence, Ms. Dasi's statement, and Sergeant Msolo's statement. bayakhuluma futhi ukuthi lapho-ke inkosi yenkantolo kade ibuke necala leli-ke lapho-ke yagqiniza kabanzi-ke ekudabeni-ke lwalokhu kade bekubhalile ngaphansi kwesigaba saka-220 kusho ukuthi inkulumo kade-ke ivunywa-ke lapho-ke futhi nokuthi ngabe yini abayithola ngesikhathi kade besenza lapho ukuhlolwa-ke komzimba lapho-ke yathi mhlawumbe ama-forensic evidence futhi nokuthi yini abayithola ngaphakathi kwama-forensic evidence-ke ngesingisi-ke ne-statement sakadasi futhi ne-statement somseshi wecala lapho-ke kade kumnumzana lapho noma mhlawumbe umsolo isibongo sakhe-ke ukuthi wakhuluma inkulumo yiphi-ke ngesikhathi lesi bekaletha ufakazi bakhe that there is no disputing that the applicant's house was the crime scene. No direct inference can, however, be drawn between the crime scene at the applicant's house and the participation in the events that led to the death of the deceased. Nokuthi lapho-ke ngabe mhlawumbe lokho kwenzeka kanjani-ke ngesikhathi kade kusenzeka ngaphakathi kwaleli khaya lakamufi kade kuye futhi bekamangele lapho-ke futhi ndakhona ukuthi kade kusesele kuyindawo yesigameko nokuthi ngabe yini kade iqukethiwe lapho-ke. The High Court relied entirely on Mrs. Dasi's statement to place the applicants on the scene and establish his involvement in the fatal assault. Ms. Dasi's statements therefore plainly played a decisive role in the convictions of the applicant. But lapho-ke ushuthi inkosi yenkantolo mhlawumbe inkantolo lapho-ke yalekelelwa mhlawumbe yasizwa istatement lapho-ke desenziwe uDasi ngaphambi ukuthi ashoneke istatement leso kade bathi yisona desibeka lapho-ke umuntu kade yenza isicelo ngaphakathi kwendawo yesigameko nokuthi mhlawumbe wabadlala siphi isikhangiso ekuthizeni ashayeke uDasi-ke lapho-ke futhi bathi istatement sakadasi yisona-ke salekelela kakhulu ekuthizeni-ke kugwetshwe-ke lapho-ke umceli lo noma umuntu kade elethe isicelo sakhe. It is submitted that Mr. Makeleni's statement is crucial to place assailants on the scene. Bathi kubalekile ukuthi istatement sakamnumzana uMakeleni samkelweke ngoba yisona esibeka lapho-ke abasolwa ngaphansi kwendawo yesigameko. Read defense's heads on behalf of accused number 4.
So that is the only portion that refers to Mr. Makaleni's statement, my lord. And as we undertook that will try and neaten up the submissions pertaining to Mr. Makaleni, correct all the typing errors, we have since done that. It's nothing new, my lord. We just a separate document, and I've given a copy to my to my colleagues. It's okay. In essence, it's the same document. The only difference, my lord, is there was a lot of unhappiness from my colleagues that we are introducing something new. It's nothing new, my lord. We're saying that the evidence of Makaleni is on record, that in considering the evidence in this matter, the court should also consider the evidence of Makaleni, and we're saying what the legal basis is for the consideration of the evidence, namely that by introducing the document, they agree to the hearsay evidence. Alternatively, in terms of the interest of justice test, that the evidence be allowed. That's all that we say, my lord. Nothing new. It's already on record. Thank you.
Iphelele lapho-ke inkulumo-ke ethimba labashushisi futhi basho khona lapho-ke ukuthi ilokho kuphela bebafisa ukuthi bakujobelele mayelana nenkulumo yabo bathi futhi lobu akusibo ubufakazi obusha-ke lapho-ke ngoba-ke lokhu sele kukhona ngaphansi kohlelo owashicilelwa la ngaphambi kwinkosi yenkantolo bacela-ke futhi ukuthi inkosi yenkantolo-ke esamukeleke le statement lesi mhlawumbe lodaba lolu lwenkulumo ade khuluma lapho umnumzana-ke uMakeleni.
That certificate has been handed up as exhibit ZZZ in brackets 4.
Bathi futhi nencwadi-ke embikayo ukuthi yena-ke sele washona bayibiza ukuthi death certificate ngesingisi bathi nayo sele ikhona ngaphambi kwinkosi yenkantolo-ke nayo futhi bayiqaphile lapho noma mhlawumbe bayimakhe lapho ukuthi imibuki noma kola ngaphansi kwimibukiso ka-ZZZ4.
That is, sir.
That's it, my lord. There was one portion that my learned friend wanted to bring to the attention of the court regarding the proceedings at Boksburg Magistrate Court, namely Exhibit EE pertaining to what accused number 4 would have said. We are mindful of the what the court mentioned yesterday, that was before the litis constantatio, but the fact of the matter is that it is on record. We just want to mention, to put that on record.
Yeah, fine, I checked it. I told you I dealt with the same issue.
Yes.
There's an AD case. Actually, there are two. They arose as a result of a magistrate in the regional court in Mthatha. He wanted to appoint two what are the guys who assist these guys?
Assessors.
Assessors. He wanted to appoint two assessors. But what he did is, he appointed these two assessors after the charges were put against the accused. There were about 3 or 4 accused in that case. But in any case, the evidence was not yet laid. So Falam was the judge there, and a gentleman called, I've got it, I would say, we must give you that thing. Falam and his co-judge, the 2 judges who were to attend to the review on this matter. And they held that before these guys were sworn, properly sworn, there was no evidence laid. So even if you can say the magistrate delayed in swearing them in, but evidence was not laid until these guys were sworn in. But they thought it had to be contemporaneously done. But these 2 judges, intelligence dictates that they're correct, because if the evidence is laid because the judges, the 2 assessors were sworn in, it would make their sitting ineligible, because they've got to hear everything that starts as from the plea downwards. But Bennett goes on and says, if there's no litis constantatio, the case has not commenced. He's right.
Yes.
I can give you the citation, as I say.
Yes, that we accept, my lord. But
yeah, fine.
There was another complaint by my colleagues that their attention was never drawn to those proceedings.
No, it was drawn.
Yes, we have. My colleague has got those relevant portions
Yeah,
where
you can read them so that.
where they specifically ask for those proceedings.
Yeah, fine.
Yes, and we just wanted to place that.
Okay, fine.
That
No
on
problem.
record.
I recall, because Mr. Ngomezulu was still there, and there was an argument whether Mr. Mjiako was appointed, blah, blah, blah. I remember that argument.
Yes, yes.
But read that record.
Yes, we just want to.
Because the point is, it is on record.
Yes.
But whether it is evidence, that's what is
that's
another matter.
Yes, there's
Okay.
something else. Yes.
Yeah.
I'm sorry, my lord. Still, I don't understand, because the court has made a ruling. The state is still pursuing on the very same issue.
Yeah, but
I don't understand.
I hear you. But he wants to show that what he was saying is what happened on the 27th in court.
What is the relevance of that?
Ask him, because he says you are the guys who are saying that never happened.
But it can be done later. It's not the end of the road.
No, let him do it so that we're through with it.
Yeah, I'll just quickly whilst we're still looking for that, this exhibit EE, the proceedings of the 27th.
Yeah.
Advocate Nisi says we had actually requested those records from the state. I think it was almost last year, September, October. We gave them a formal letter saying that, can you at least finish us with the transcribed record of the proceedings of that day? Because we are well aware that the copy of the charge sheet that my colleague is referring to, which is Exhibit EE, that is a handwritten copy. And that copy, God forbid, magistrates do not write all that what is happening and being said in court. They are trained to write that which they think is necessary for that particular day, but a transcribed record reflects whatever that happened on that day verbatim. And we then, on that basis, my lord, handed those transcripts to them. And during the proceedings of 30 January 2024, line 10 to 15, Advocate Mnisi says, despite the fact that there are those records that have been made available, the disc and the record of the transcript, quote, but we have read those, and Advocate Mnisi says, I have read them, they have been handed to us now. So it's just a confirmation, my lord, that we did bring that to the attention of our colleagues. But there's just that one portion which of Exhibit EE, which we want to put in record, and this is the proceedings of 27 October 20.
I'm going to object, my lords, to this so very unknown procedure. The issue, my lord, in this application, or the issues in this application, are specifically defined. There's been an application by accused number 4 that on the basis of the fact that the state has not been able to establish a prima facie case against him on all the counts, he requested the court that he should therefore be discharged at the close of the state's case. The state's response, the manner in which they've responded, that is the issue that needs to be determined at this point in time. Now the state stands up, and it is struggling. It's very struggling. It stands up and say, no, but there's a Makaleni issue. There's the record of the transcript, my lord. What do those submissions have to do with the application that is so circumscribed, that is so specific? And I've indicated on Tuesday, my lord, that the state, if it feels like there is something that they have missed in the presentation of their evidence, which I would refer to as struggling, they would still have the opportunity. There is nothing wrong in terms of the procedure for them to stand up and say, my lord, we acknowledge the fact that we had already closed our case. But there is information that we feel, in our view, that would be the state saying that we can use at the end of the state, at the end of the close of the case, to make an argument that will supplement our application for a conviction. Then the court will have to make a decision on whether or not it grants them that leverage or that allowance or that indulgence. But not now, my lord. Because if I were to stand up and start to address the issues that the state is now raising, this procedure will be very precarious. It will be unheard of in any civilized legal system, particularly in a system that is codified. And ours in South Africa is codified in terms of the Criminal Procedure Act number 51 of 1977. Such procedure is not allowed, my lord, particularly when there's an application in terms of section 174. This section must be dealt with and be finalized. Then the state, as I've said, if they feel there is something that they need to add into their struggling evidence, then they can stand up and say, no, we also want to add this another struggling point in our struggling evidence through an application. The state does not even apply now. It simply says, we also want to add this, we also want to add this into the record. What is the purpose of this sitting, my lord? Is it to introduce new evidence or to make a determination on whether or not accused number 4 has been able to bring to the court an argument which in the mind of the court says that it should be discharged, or the state which in the mind of the court says accused has not been able to discharge the honors in terms of section 174. Those are the issues at this point in time, my lord. Otherwise, the procedure that is being followed here, fiasco does not even begin to explain it, my lord. It's unheard of.
Yeah, fine. I've heard you. You see, the problem with you and your colleague arguing, you discuss things in my absence, and then you want me to solve them. You see, he says, you approached him. I wasn't there. No. And you complained about A, B, C, D, E, F, G. No. And now he says he's rectifying what you complained about. Am I correct, sir?
That's actually, it happened in court on Monday, as he says. That's what they said.
Now I'm being blamed for not knowing the procedure.
Yes.
No, my lord. I'm not saying the court does not know the procedure. But what I'm saying is the procedure that is being followed here is unheard of. That cannot be equated to mean that the court does not know the procedure, my lord. Now, the issue is, my lord, there are issues which have been raised here. And the procedure at which we are now, which is an application in terms of section 174, does not allow parties who have not made an application in terms of that section to respond to the issues which the court needs to determine. Accused number 1 and accused number 3, accused number 5 and accused number 2 are not party to these applications. And yet there is evidence which in their mind seems to be evidence that is being introduced through the back door, my lord. Would we then be afforded the opportunity to respond? And the court said on Monday, yes, you will then respond. But state proceeds, still continues to introduce new evidence.
Okay, so are we...
Through the back door, my lord. Well, I don't know if this procedure, if the court really affirms this procedure, I'm in the hands of the court.
Don't talk about the procedure, because I'm telling you what you do in my absence.
No, but my lord, there was no agreement. There is no agreement that we've...
But you spoke to him.
About what, my lord? We spoke to him about what?
Okay, fine. That's it.
I never speak to the state, my lord, because I know the way in which they operate. Everything that I do, I make it a point that it is done on record. I know the way in which they operate.
As we pointed out, that is, we're responding to their complaint on Monday that they were not made aware of the proceedings. But, my lord, we've made submissions. We have summarized the evidence. All that we are saying is stating the obvious, that in considering the conspectus of the evidence, these are the issues that are already on record that must be factored into the equation. Nothing new. We're putting on record what ought to be considered. I don't understand the objection by my learned friend. Nothing, no new application. We're just saying the court, as we have done, we have summarized the evidence. These are aspects that we could have mentioned in the summary of our evidence. We're just saying, in addition to the summary that we've given, these are also the aspects that must be factored into that summary, nothing new, my lord.
Okay, is that the end of the argument?
Yes, so
So what do we do?
yes. I think Advocate Ngumalo wanted to respond to the state's submissions, and that's where we are in terms of the process. But there was that one aspect that we wanted to put in record that appears on Exhibit EE, which would form part of, which forms part of our submission as far as accused number 4 is concerned. And as I say, this is not something new; it's already on record. The proceedings of 27 October 2020, page 5. The last two lines, accused number 4, Your Worship, I do not see the necessity in acquiring legal assistance because we do not have money since we've been brought before court. The people who are supposed to be appearing before court are not before court because they have money. That's all that we wanted to put in the court.
Okay, fine. Yes, yes. Is that the end of this application now?
Yes, those are our submissions, my lord.
Yes, Mr. Normal. Are you through too?
My lord, I'm not in a position to respond because in respect of the statement of Makaleni, the 7 requirements in terms of the Act have not been met. I've never heard the state discussing the issue of the nature of the proceedings, the nature of the evidence, the purpose for which the evidence is tendered, and the property value of the evidence of that statement. In fact, my lord, in my address,
You're not quoting the SC Act, I mean the Constitutional Court case of Darcy. You're not quoting that case, sir.
no,
Yes, the one that we quoted, my lord, it's Kappa.
Because it is the
Kappa.
yeah, it is the Constitutional Court speaking there. It's not the
the Act speaks.
yeah.
The Constitutional Court refers to an act. So
Yeah.
when an application is made, the 7
It's a judgment
requirements.
of the Constitutional Court. What
Yes.
more do you want me to say?
Yes, I know
And
that.
he's reading that judgment.
Yes,
And that judgment says there are 7 categories which must be satisfied.
yes, yes.
So what is the problem?
Has the state satisfied those requirements?
I don't know if I'm saying that judgment, as I understand it, that's what it says.
I understand, my lord. Further to that, in my application, I never referred to the statement of Makaleni. So how does it find its way through this court in this
Yeah,
application?
fine, you can argue that if you want.
Because, my lord, I've referred this court to the case of Mkedezi to say that for the 5 requirements, they must be met for my client to say he formed common purpose with the others. But now the state is referring to the Makaleni statement, of which I never referred to Makaleni, as to how Makaleni and accused number 4 is related in respect of this application that I've
Yeah, you
dealt
can
with.
argue that I must reject that argument.
That is my argument,
Yeah,
my
fine.
lord, that I respectfully ask the court to reject that evidence.
Yeah.
It finds no application in the application that I've made before this court on the 25th of August. That was
Okay.
on Monday. Thank you, my lord. Thank you.
Right, so when do we reconvene?
So, my lord, may I perhaps find clarification? On Tuesday, when the issue of Makaleni reared its ugly head, Advocate Munisi stood up and inquired from the court whether, because of that, the Makaleni issue, which was not canvassed in Advocate Ngumalo's application, and it does touch on particularly Mr. Ntanzi. And further, my lord, regarding the manner in which the response by the state seeks to have the extracurricular statements of accused number 2 apply to all accused persons that are before court, which is anti the the Mhlongo case. So on that basis, Mr. Advocate Munisi asked whether we will be afforded an opportunity to reply, and the court confirmed that we could reply. Hence, in the morning, I was asking, is that procedure? Because those are fundamental issues in this application, my lord. It has escaped the circumscription for the application and the reply. Now we are in Stswana. We are touched by blood. That was not meant for us.
You know what? If you guys apply the law, and you know the law, there won't be problems. If he knows the law and he applies it, there are no problems. If he does the same, he applies the law and does it, and he argues, and you say, I must write a judgment. I'll write a judgment because I know the law.
Yeah, because we found ourselves perplexed.
So if you want to supplement your heads, you can do it, no problem. If you think it's necessary.
My lord, I stand as an officer of the court because I did not per se make an application. But if I see issues that I feel as an officer of the court that things are not going well, my lord, I should stand up and ventilate and assist.
I can tell you what is your problem.
Yes. What is my problem, my lord?
If you read that charge sheet,
Yes.
it says the 5 gentlemen there are charged in terms of section, common purpose, and then it's section 51 what?
It's 51.
Just read 51.1, because that is the problem, I can tell you now. Jesus.
51 is more of minimum sentence.
Yeah, the conspiracy part. They not charged with conspiracy.
Well, we do mention in the indictment that
To say?
they are charged in terms of common purpose and or conspiracy, but
In the indictment.
yes, in the indictment,
I think that is the problem here.
yes.
As I understand the law, if you are charged in terms of a common purpose and a conspiracy, it applies to, according to the state, not me. It applies to everybody who's charged.
My lord, 51 deals with sentence.
No, he says it's not. He says he mentions it as a
Yes.
conspiracy.
Yes.
Okay,
Yes.
that's how I understand it.
Because, my lord, for me, the concern is this Makaleme issue. The procedure that I know is that before the close of the state's case, the state, if it wishes and intends to lead or to have the court admit hearsay evidence, it stands up and makes an application to the court to say, my lord, we've let hearsay evidence, for example, of Makaleno, and we are making an application for that hearsay evidence to be admitted. And both the parties, the state argues the admission and we argue against the admission. And the court makes a ruling. Now we are stuck here where these things enter via the back door.
I only make a ruling when I deliver the judgment.
Yes.
Not before.
Yes.
Okay. I listen. Before then, I listen.
Yes.
If he misquotes the law, I just listen.
Okay. Yeah, because that was my concern that the law was
So
quoted.
if you and Mr. Ngumalo say there is no law like that in South Africa, fine.
Yes, because
I can tell you there is a law like that. State S versus roll.
a law like
Wait. There's another one also where this judge, he's a very experienced judge, it's, I think it's Falam. Falam was handling a case in Joburg. The state and the defense argued, and they closed their case, both of them. And then Falam made an order that there should be an inspection in loco held, because there is an aspect which he wants to examine at the scene of the alleged murder. And it did that.
my lord.
No, I'm telling you
Yes.
this is
But
something
before
new.
I sit down, my lord, let me just also refer to the law, my lord. The infamous Indlovu SCA judgment case, the one that was
Yeah,
overturned.
Goldstein.
Yes,
You should sit in this court with me.
Yes, where
Goldstein.
Judge Cameron, my lord, and I just want to read this paragraph, and then perhaps we can engage with his
He
lordship.
wrote
further.
the appeal.
Yes,
Goldstein wrote the judgment in Joburg.
yes,
And then Cameron, when he went to the SCA,
yes,
he handled the appeal.
yes. But that one, my lord, and I'm quoting at 338
Yeah.
A2C of the judgment, it says, third, an accused cannot be ambushed by the late or unheralded admission of hearsay evidence. The trial court must be asked clearly and timelessly to consider or rule on its admissibility. This cannot be done for the first time at the end of the trial, nor in argument, still less in the court's judgment, nor on appeal. The prosecution, before closing its case, must clearly signal its intent